morning. This is Attorney Karen Jimeno. We'll have more insights on the impending impeachment with the former Supreme Court Chief Justice here at the forefront. He's a revered figure in the Philippine legal landscape, lending his voice at a time when the nation is at a constitutional crossroad. With the wisdom forged through decades on the bench, former Supreme Court Chief Justice Reynato Puno is willing to offer clarity on the sanctity of the rule of law and the role of institutions in turbulent times. As the impeachment proceedings against Vice President Sara Duterte unfold, how does the former Chief Magistrate view the weight and consequences of this historic process? With us this morning, live at the BNC studio, is the former Chief Justice of the Supreme Court and Chairman of the Philippine Constitutional Association, or PHILCONSA, Reynato Puno. Good morning, CJ Puno.
Good morning, Attorney Karen. Thank you for the invitation and for the opportunity to share some insights on what is happening to our impeachment court.
CJ, a lot of us in the legal profession know that you're a living legend in the legal field. But to refresh the memories of Filipinos, especially the younger generations who might not know your background, we'll start to get to know you better and we'll show you photos and you'll have 30 seconds to give us a brief background. So we'll start with this picture.
Okay, salamat.
So this is UP Law. In 30 seconds, can you explain or share with us, you come from the UP College of Law, and tell us also what made you passionate about the law, that you also studied in several universities, the Southern Methodist University, UC Berkeley, and the University of Illinois. Timer starts now.
Well, yes, I graduated from the UP College of Law in 1962. And during my student days, I happened to be the editor-in-chief of the Philippine Collegian. And after graduation, the university also conferred to me the most distinguished alumnus award.
You eventually got that award, Most Distinguished Alumnus.
Yes, during the centennial celebration of the whole university.
And Chief Justice, you were also in 3 different law schools abroad,
Yes,
where you took up law as well.
Yes.
What made you study that much? Ang dami niyo pong extra degrees, all in the law.
Yes, I thought that I could fine-tune my legal knowledge by attending these very good universities, especially the University of California at Berkeley. And I profited a lot from attending these law schools because the professors were very visionary in terms of projecting what the law will be in the future.
In your family, kayo po ba ang nag-law lang among your siblings, or did you have anyone that inspired you to take up law?
My father was a lawyer, and the first 3 children were all lawyers. We all graduated from the UP College of Law.
So marami po kayong naging lawyers sa pamilya. Kayo po ba ang unang nag-Supreme Court in your immediate family?
That's right, yes. Although my eldest brother was a judge of the Court of First Instance. Yes.
So lahat kayo po overachievers.
Yes.
And let's look at the next picture. And this is the Office of the Solicitor General. You started your law career as a private practitioner and a professor in UP also. And you became part of the Office of the Solicitor General in 1971 and stayed there for almost 10 years.
Yes,
In 30 seconds, what convinced you to work for the government? Actually, we'll give you a minute po para dahil mahaba po yung kwento ninyo. Timer starts.
Let me correct correct your statement. I did not teach in the UP College of Law. But I did join the government, and I was invited to join the Office of the Solicitor General by then Solicitor General who became Justice of the Supreme Court, Felix Antonio. I thought that it's an opportunity to give my talent to the government in terms of public service. And so I grabbed the opportunity.
And you were there for 10 years. At some point, did you consider to stay there until you finish your career? To become Solgen later on?
No, I never thought of becoming a Solicitor General. Although I was the most senior Assistant Solicitor General at that time. And when the Solicitor General is out of the country, I had occasions to act as Solicitor General. Yeah.
But even then, you decided not to stay in the OSG?
Because the natural projection of the career at that time is that from the office of the Solicitor General, you joined the Judiciary.
And was that your dream po, ever since bata ka pa, na mag-Judiciary?
Not really, but later on, that became my objective.
Okay, and so let's look at the next picture. You ended up entering the Judiciary first through the Court of Appeals, and you served as Deputy Minister of Justice in 1980.
Yeah, right.
But you were also appointed by President Cory as the CA Justice in 1986. So basically, you crossed over from the Marcos administration to the Cory administration after we had the 1987 Constitution. In 30 seconds, can you share with us what was that like, being in the Court of Appeals? Timer starts now.
Yes, I was in the Court of Appeals before the EDGE revolution. And as Associate Justice of the Court of Appeals, the executive department asked me to transfer, to cross over the Department of Justice as a Deputy Minister of Justice. And it was there that the EDGE revolution came to pass. And we were all asked to submit our resignations. It's a revolutionary government. And I'm proud to say that of the Deputy Ministers of Justice, only 3 resignations were not accepted by President Cory Aquino. And
you were one
was
of
mine,
them.
yes.
Sino, do you remember sino po yung the other 2?
The other one was the National Treasurer. I forgot the name of the other one. And since I was retained, I was able to go back to the Court of Appeals.
When you were at the Court of Appeals, what was the most memorable case for you that you remember having to decide?
There were important cases, but the kind of cases that go to the Court of Appeals are not as important as the cases that go to the Supreme Court.
Yes, understandable. But during your time as a member of the Office of the Solicitor General, umabot po yung time that were the martial law years.
Yes.
How was that experience like? You'd had to defend the government's position in several cases during the martial law era.
It was a learning experience, a very fruitful one. And I like to think that the positions taken by the Office of the Solicitor General at that time, especially cases involving the interpretation of the difficult provisions of the Constitution, contributed a lot to the building up of our rule of law. There were instances when, several instances when the Solicitor General, agreed with the petitioners. Some petitioners were arrested unlawfully, even under the terms and conditions of martial law.
So you mean at that time, the Office of the Solicitor General even took the position of some petitioners against the government?
Yeah, that's right. And we contributed to what should be the proper interpretation of some provisions of the Constitution, especially on the matter of balancing of powers.
Has it ever happened during your time where the OSG also refused to defend or represent the government in the same way that happened to us recently when it came to the matter of the issue of the arrest of former President Duterte?
The cases where we disagreed with positions of government mostly refer to cases where the petitioners should have been acquitted from the cases. Yeah.
So let's look at the next picture. And Chief Justice, this was the time that you became an Associate Justice of the Supreme Court. So you were appointed by President Ramos as Associate Justice in 1993, and years later you became a Senior Associate Justice. In 30 seconds, can you tell us the highlights of your first 20 years as Supreme Court Justice? Timer starts now. Sorry, in 1 minute. We'll give you 1 minute.
Yeah. Well, I had occasions to, like other justices, to write landmark decisions. But more than this, I like to think that my legacy to the rule of law would be the issuance of the writ of amparo,
Yes.
the writ of habeas data, the writ of kalikasan, the issuance by the Supreme Court of its internal rules and regulations, as well as the approval of the rules on arbitration.
Yes. So you did have several innovations in the rules of court, especially as you mentioned, like for example, the writ of amparo, writ of kalikasan.
Yeah.
How did you come up with these ideas?
We issued the writ of amparo. That was during the presidency of President GMA.
Yes.
And at that time, there were also plenty of extrajudicial killings. In fact, the United Nations Human Rights Commission sent a representative here to investigate us. And they sent Professor Philip of Harvard University. So he visited me and asked me how the Supreme Court can alleviate the situation. And that is the background. I thought about it. We made researches on how other countries, respond to these extrajudicial killings, especially in Latin America, South America, and the others. And we stumbled to that remedial action, the writ of amparo. So we studied all the writs of amparo in these countries and contextualized the same and adapted it. And that writ until now is still used. In fact, it's being used more than the writ of habeas corpus.
Mm-hmm. And in your opinion, are you happy with the way the writs that you innovated, writs of amparo, writ of kalikasan, and the way that they are now being utilized?
Yes, but I am hoping that the Supreme Court would review how these various writs are being implemented and come out with amendments or changes on how far they can still be strengthened.
Okay, and to adjust, I suppose, to whatever changes have happened in the past years.
Yes, right. Especially the rate of habeas data.
And then let's look at the next picture. And this is in your career as the Supreme Court Chief Justice. You were appointed by then President Gloria Macapagal Arroyo as Supreme Court Justice in 2006 and retired on your 70th birthday. In a minute, can you describe to us your stint as Supreme Court Chief Justice? What was the highlight of your career?
Yes, those were the highlights. I really planned out what I should be doing, what the highest court of the land should be doing in 4 years. And so I analyzed the situation of the country, what is going on politically, socially, and economically. And that is how we responded. The writing of the writ of amparo on my first year. On my second year, we wrote the writ of habeas data. And on the third year, the writ of kalikasan. We were the first to write a writ of kalikasan in the whole world. And that was in anticipation of the various problems that will be brought about by climate change. And in addition to that, I saw to it that the Supreme Court should have its own rules and regulations. It was, to me, inappropriate that all courts had their rules and regulations except the Supreme Court. And the Supreme Court was already in existence for so many decades.
Yeah.
And so I personally wrote to it that before I bow out, the Supreme Court should have its own rules and regulations.
But prior to that, CJ Ray, ano po yung reason bakit walang sariling internal rules and regulations yung Supreme Court? Was it to give a lot of flexibility, or did they benefit from that, the prior Supreme Court?
Yes, that may be the reason, but that was the subject of a lot of criticisms, and the public, was asking why the Supreme Court has no rules and regulations. I thought, however, that even if the court would adopt its internal rules and regulations, that would not impede the function of the Supreme Court. Anyway, it has the inherent power to change its rules and regulations.
And you also banned nepotism among judges. Is this something that continues up to this day?
Yes, during my time, I remember one of the acts that I did as a Chief Justice was to ban the employment of wives and relatives in the Court of Appeals. Well, of course, that was not a very popular
Yes.
move, but anyway, that stopped the practice of some justices employing their wives as secretaries or confidential assistants. And they followed it, but I do not know whether that rule still exists.
Still exists today. How did you find time to raise a family? Your career was very busy, and of course, for a lot of lawyers, it was very exceptional. You did OSG, Court of Appeals, Supreme Court, and of course, ultimately being Chief Justice. That's really a highlight for anyone in the legal field. But did you ever find the time to also spend quality time with your family?
Yes, but I would say that if there is anybody who should be given that credit, it should be my late wife.
Siya yung talagang nag-alaga po sa pamilya ninyo.
Yes.
And right now, after all of this, did you ever consider running for public office, given your background?
When I was about to conclude my career in the Supreme Court, there were lots of groups that were pushing me to run for the presidency. But that's not my cup of tea. So in the end, I said no to all these movements for me to run as president. Yeah.
And what kept you busy after retiring as Chief Justice?
Well, after retiring, there were offers of directorships. I accepted some of them, and I concentrated on church work and related activities. So I'm chairman of different foundations like the Philippine Bible Society, the World Vision, and others.
Are you do you have any relations with the Puno brothers, like Dong Puno, for example?
Yes, the Justice and Secretary of Justice Ricardo Puno was the second or third cousin of my father.
Okay, so meron pong relation.
Oh yes, we belong to the Puno clan.
Oh, malaki po ba yung
Malaki,
Puno clan? And very
malaki.
close po kayo.
Yes, yes, yeah.
So now let's go to the impeachment po.
Yes.
Former Senate President Franklin Drilon guested here before, and he mentioned that if he were Vice President Sara Duterte, he would question the impeachment complaint on the ground of jurisdiction because of the fact that it crossed over, or it is going to cross over from the 19th Congress to the 20th Congress. What is your take on that legal issue? Can an original impeachment complaint cross over from one Congress to another?
That is a good question. It's a noble question that I think would ultimately land in the Supreme Court. But reviewing constitutional law, reviewing our case jurisprudence, reviewing our the historic origins of our provisions on the matter, the study shows that the impeachment court is a continuing body. The Constitution vested jurisdiction on the tribunal itself, on the body, on the institution. The jurisdiction was not vested on the personality of the senators. In other words, the senators may come and go, but that will not affect the continuing jurisdiction of the Senate as an impeachment court. And this practice is well rooted in U.S. law and jurisprudence. The latest example that we saw how this practice was perpetuated is the case when President Clinton was impeached. The impeachment proceedings crossover the Senate of the United States. In other words, despite the changes in the political complexion of the impeachment court, the jurisdiction continued.
Well, yesterday we also had the spokesperson of the impeachment court, Attorney Tonggol, here, and he said that the Senate, as an impeachment court, asked Congress, among other things, to ratify the impeachment, the articles of impeachment, so that it can cross over from the 19th Congress to the 20th Congress. Is that necessary for the articles of impeachment to cross over from one Congress to another?
Well, again, that remand order has been the subject of intense and continuing criticisms on the part of the academe, the deans of the College of Law, professors of constitutional law, and almost always the view is that that order is constitutionally suspect, and the arguments are well laid down by this scholars. And moreover, you do not find this requirement in the internal rules of the Senate. If you allow that remand order to subsist, what can next follow? The Senate can later on say that compliance by the House, when the House passed this resolution, making the proper certification, the Senate can come back and say that that is not sufficient. We need more requirements to be followed.
But is that unusual for an impeachment process? Because I know that rules of court apply supletorily to impeachment proceedings, but is the Senate, sitting as an impeachment court, not allowed to come up with their own rules?
Yes, the Senate, of course, as an impeachment court, has that inherent power to promulgate its rules and regulations that is specifically provided in Article 17 of the Constitution. But however it may be, the rules and regulations of the Senate cannot infringe the Constitution.
And what aspect of that remand order infringed the Constitution?
Well, you read the Constitution, it says that the power to initiate this impeachment proceedings exclusively belong to the House. While that power exclusively belongs to the House, it does not mean that the exercise of that power cannot be questioned. Its constitutionality can be questioned in the Senate itself. Mm-hmm. But it can only be questioned by the respondent, the Vice President. They can question this in the form of as an affirmative defense. In other words, the defendant can raise that there is non-compliance with the 1 year rule, and therefore there is a lack of cause of action. But lack of cause of action does not mean lack of jurisdiction. Mm. So the defendant should be able to raise this. But it can only be heard by the impeachment court in the proper time, because it is only an affirmative defense that constitutes a lack of cause of action. In other words, the impeachment court will first hear the evidence of the prosecution, and then later on hear the side of the defense. And it is at that particular time when the impeachment court can look at that issue, whether there was compliance with the 1 year
bar
rule. And this is not an easy matter, because the matter will be decided only after presentation of evidence by the parties, because the facts are not settled. The facts have to be settled by means of a presentation of evidence. It is not strictly a question of law. And given that premise, the impeachment court cannot by itself raise that issue, because they will be constitutionally suspect. They may be suspected of bias or prejudice.
Okay, so your issue here is not the fact that there is a question on the 1 year ban rule, but the fact that the Senate impeachment court acted motu proprio without that motion coming from the respondent here.
That's right.
So, in your opinion, was the Senate's action a procedural necessity or a constitutional overstep? But before you answer that question, we'll have to take a short break. At the forefront, we'll be right back. Welcome back at the forefront. Chief Justice Ray, was the Senate's action a procedural necessity or a constitutional overstep?
It's to me, and this is the view of other experts also. It's a procedural overreach. Cannot be justified under the Constitution, cannot be justified under their own rules.
Why can it not be justified? The lower house,
Yes.
Congress, is not a continuing body. Is that correct? While Senate as an impeachment court, you were saying legally is a continuing body. Congress, the House of Representatives, is not a continuing body. So is there any logic for Senate as an impeachment court to ask for a ratification for the 20th Congress so that the impeachment complaint can cross over to the next Congress?
It's the impeachment court that is a continuing body. That does not mean, however, that the House, on its own volition later on, may resolve to withdraw the complaint for impeachment. But that is up to them. The impeachment court need not order the House to give that kind of a compliance.
But if, for example, someone brought that issue specifically on the legal question of whether the articles of impeachment can cross from one Congress to another in the Supreme Court, if they brought that question to the Supreme Court, would the Supreme Court's decision, if they were to say that that was not legal, affect impeachment proceedings that are, for example, already initiated?
Certainly, that will affect the proceedings. And as I said, it's a novel question. It's an undecided issue in our jurisdiction. But again, the question is, will the court step in? If it decides to step in, what will be the timing? All this about to be considered by the Supreme Court. But at this time, the impeachment court should not anticipate all these problems, because the net effect of that would be to continue delaying the trial of the case.
And the Philippine Constitutional Association, with you as chairman, came out with an official statement saying that you were calling on the Senate to perform its constitutional duty to proceed with the impeachment. Can you explain to us this statement here that this remand order constitutes a circumlocutory delay?
Yes, you look at the time that has been spent by the impeachment court on this particular case. Since February, I think the articles have been forwarded to the Senate. And so February, and now it's already June, and the trial, the hearing of the case has not been started. The defendant has not been summoned. She has not filed her answer yet. And the effect of this remand order is to put the jurisdiction of the impeachment court in suspension, in limbo. We do not know what will happen to this remand order.
But if Congress were to comply with the requirements there, which is one, a certification, they're asking Congress to certify that they complied with the one-year bar rule, and then for the 20th Congress to ratify the articles of impeachment, then the trial should proceed, right? So is the ball now in the House of Representatives court?
I'm not really sure whether that will really happen. Because if we proceed from the premise that the Senate impeachment court can do that. What will happen if the impeachment court would issue further orders? It, I do not know whether I heard it correctly, that there may be questions on whether the resolution is the proper form, or whether this resolution of the House should be published in a newspaper of general circulation. There may be other conditions that will be imposed, the verification of whether the signatures were given freely and voluntarily. What will happen if the Senate impeachment court will issue other orders?
Yeah.
Say
So
that you come out with a certification that you have enough evidence to prove this particular charge. And this may go ad infinitum.
So this
If,
is what
if
you were
concede
saying. Yeah.
that the power really is not unconstitutional.
Yeah, so this is where you were saying that the circumlocutory delay is made up of or constitutes the imposing novel requirements that are not found in the Constitution.
Yes, perhaps the better thing to do for the impeachment court is to issue traditional orders that are beyond constitutional suspicion.
Will the requirement for the House of Representatives to certify that they complied with the one-year bar rule, does that have any legal weight? There is a pending petition right now in the Supreme Court also on the issue of the fact that there were 4 articles of impeachment that were filed in the House of Representatives. So would that have any weight in order to secure the validity of the 4th verified complaint?
Yeah, that's a very good question. What is the value of this certification? Will that foreclose the issue of compliance or non-compliance with the one-year rule? If that will foreclose the question, I'm sure the defendant will raise a lot of complaints. If that has an effect, that would be adverse to the position of the Vice President. So what is the value of this certification? What is its weight?
And what is the weight, in your opinion?
To us, precisely, we are saying that that is void.
Wala siyang weight to cure any defects. So for example, meron ngang defect in terms of the one-year bar rule. The issuance of a certificate from the House of Representatives will not cure that defect.
It will not. Otherwise, they would be depriving due process to the Vice President.
In a press briefing yesterday, Senate President Cheese Escudero said that the official statement of PHILCONSA came from a group that was headed by Speaker Martin Romualdez, so that he's not surprised with its position. What is your response to that comment?
The speaker is the president of PHILCONSA, but he has nothing to do with the statement that was issued by the board of governors of PHILCONSA. He did not add any word, any period, any comma to that statement. In fact, it would seem to us that the position taken by the House, led by the Speaker, is contrary to the position of PHILCONSA. The position of PHILCONSA is that this remand order is void, constitutionally void. On the other hand, the House, led by the Speaker, complied with the remand order. So the positions are in opposite.
Yes, yeah.
Are opposite. So you cannot say that the statement of PHILCONSA was influenced by Speaker Romualdez. And this is a perfect example of an ad hominem argument.
Ad hominem meaning it's directed against people,
Yes,
not
yes,
on
right,
the legal issue.
Right.
So wala pong kinalaman si Speaker Martin in terms of initiating this PHILCONSA
contrary nga
statement.
yung position nila by complying with that requirement of certification. they are impliedly admitting that the order is valid.
And the PHILCONSA's official statement also mentioned that remand order constitutes grave abuse of discretion on the part of the Senate Impeachment Court. So if it were grave abuse of discretion, that would be something that could be a subject of a petition for certiorari that could be filed in the Supreme Court. Should someone, for example, file that petition for certiorari, what would happen? Can the Supreme Court then, if they declare that order to be unconstitutional, force the Senate Impeachment Court to convene and proceed with trying the impeachment?
Yes, the Supreme Court would have the power to come in and intervene. Again, if you will remember, that additional power given to the Supreme Court to intervene when there is a grave abuse of discretion on any branch of government or any action of government officials. That is a new provision in the 87 Constitution. So, in effect, that expanded the power of the Supreme Court. And to a large extent, the reason for that is to disable the Supreme Court from reneging on the exercise of its checking power on certain political questions. So the power is there for the Supreme Court to intervene. But whether they will intervene, if they intervene at what stage of the process, that is another question.
You were formerly a Chief Justice of the Supreme Court. How does the Supreme Court decide these type of issues, when to intervene or if to intervene at all? But before you answer that question, we'll have to take a short break. At the forefront, we'll be right back. Welcome back at the forefront. Chief Justice Rey, we were discussing earlier and you said that the Supreme Court has the power to intervene if there's grave abuse of discretion on the part of the Senate Impeachment Court. But whether they will intervene and at what point is a different question. As a former Chief Justice of the Supreme Court, how does the Supreme Court determine that? When they will intervene and at what point?
The court will consider all the factors that are relevant. Let us remember that the Supreme Court is the highest court of the land. And so it's composed of 15 justices with different philosophy, different minds. In other words, 15 republics. And so we cannot expect the High Court to act in haste. And that should be. Some would say that, the Supreme Court as the ultimate arbiter of what is the law of the land has the right to be wrong. But the Supreme Court would rather be right, not just has the right to be wrong. And our constitutional process see to it that you don't hurry up the High Court in deciding this very important constitutional issues. In fact, the constitutional structure is to give all the time to the Supreme Court to think about the issues and all their ramifications. So we do not know what will be the temper of the Supreme Court.
So bottom line po, this can take a lot of time and we do not know when they can come out with a decision if someone were to question, for example, this remand order in the Supreme Court.
Yes, it can take a lot of time. But again, as I said, look at what happened to the petition of the Vice President assailing the violation of the one-year rule.
Yes, that's something I wanted to ask you, Chief Justice Rey, because Vice President Sara Duterte filed a petition for certiorari and prohibition as far back as February 18 of this year, questioning that violation of the one-year bar rule under Rule 11 of the Constitution. And yet, we haven't heard from the Supreme Court.
Yes. the court, I'm sure, is studying all the dimensions of the issues. But in the meanwhile, the court did not issue any restraining order against the Senate impeachment court. What does that mean? It's a signal for the impeachment court to continue exercise its primary jurisdiction.
But Chief Justice Ray, won't that waste the time of the impeachment court and taxpayers' money if, for example, mag-proceed yung trial and then later on the Supreme Court comes out with a decision saying that there is a constitutional violation of Rule 11 because of that one-year bond rule?
Yeah, at the time, all that will be guesswork. For all we know, the orders and ultimate decision of the impeachment court may all conform to the requirements of the Constitution. If that comes to pass, then the decision of the impeachment court will be beyond assail. It cannot be questioned in the Supreme Court. That pending case in the Supreme Court will be moot and academic.
Ganun po yung effect niya. So
Yes.
if this trial continues and the Supreme Court is unable to come out with a decision before the Senate impeachment court comes out with its own decision, then that petition for certiorari would become moot and academic.
Yes, I suppose the impeachment court ultimately holds that there is a violation of the one-year rule. That is it. That pending case in the Supreme Court will be moot and academic.
It doesn't go into the very jurisdiction of that impeachment complaint.
No, it's just
if
a
you
cause of
violate
action.
the one-year bar rule.
It's just a cause of action. And that is why, as a cause of action, that should be raised not by any member of the impeachment court, but by the defendant herself.
Well, now that you mention members of the impeachment court raising motions or arguments on behalf of the respondent, Senator Bato de la Rosa moved to dismiss the impeachment complaint. And there have been statements from other people calling for some senator judges to inhibit. But Vice President Sara also said in a press briefing yesterday that if that were the case, then senator judges that are against her should also inhibit themselves. But as lawyers, we know that inhibition or recusal is something that is decided by the person being asked to inhibit. So in this case, senator judges themselves have to inhibit or decide to inhibit. Hindi sila pwedeng pagbotohan ng Senate na mag-inhibit sila. So what do you think? Is there any remedy for either the prosecution here or the defendants if there is a refusal by senator judges to inhibit themselves?
Yes, again, that's a very important question. Well, first of all, the motion of Senator Bato was not adopted by the Senate because at that time, the Senate was not yet constituted as an impeachment court. Mm-hmm. Well, next we go to the question of the effect of that motion to remand, being sponsored and approved by the members of the impeachment court themselves, and that would raise questions about their impartiality, their fairness as judges of the impeachment court. That is correct, that the question of disqualification will be resolved by the senators on their individual capacity. But assume that the senators will not inhibit in these proceedings, despite the fact that there may be grounds for inhibition. That the end result of that would be very difficult to predict. In the first place, fairness and impartiality of a judge, whether you are a judge in the judiciary or whether you are a judge in any other court, in administrative proceedings and so forth, the fairness of the one making the adjudication is a part of substantive and procedural due process. That was spelled out in the case of Angtibay versus CIR. And it's in the Constitution that, whether you're in an impeachment court, you are bound by the provisions of the Constitution on due process. Now, what would be terrible that could happen here is, let us hypothetically say that the impeachment court proceeds to its decision. It's a correct decision, but because of the lack of inhibition by the senators, judges themselves, their credibility is eroded. It's a correct decision, but would not be believed by the public. That would be a terrible consequence.
Outcome, yes.
The worst scenario may be, the people may resolve this case using their own power. In other words, justice here may be fought out in our streets, and that would be a scenario that we should by all means avoid.
Yes. And I agree with that, Chief Justice Ray. We should really avoid people having to go to the streets to just assert.
Yes.
Thank you so much, Chief Justice Reynato Puno Jr. It was really a pleasure to have you here today. And bitin pa po yung time. I hope we can have you back here again.
Yeah. Thank you again, Attorney Karen.
With clarity drawn from decades of judicial wisdom, Chief Justice Reynato Puno Jr. offers a steady voice amid the storm of political upheaval. His insights cut through the noise, reminding a nation that the Constitution is not a mere document, but a living covenant between leaders and the people. In times of doubt, it is the rule of law that must light the way forward. Be timely informed, be insightful of the news, always stay at the forefront. Join us again tomorrow for meaningful conversations on issues that matter. This is Attorney Karen Jimeno. Thank you for spending your hour with us.